And Sticks.
May it please the court, I was intending to take matters in the order they're set out in my skeleton argument, so dealing with each of the grounds separately rather than trying to run some of them together.
Yes.
And while I do so, I'll weave in rebuttal to my learned friend's submissions and to the extent helpful, try and answer some of the questions that my lords had for my learned friend as I go along. But before I turn to the legal principles and then to the grounds, if I may, I'd like to start with the sign and issue and have that as our focal point before we begin. You can find that there's a representation in my skeleton argument. So that's Core Bundle 1, Tab 9. And it's in colour, helpfully, on page 95 of the bundle. So standing back in my submission, this is a sign that is plainly clear and precise. It's capable of distinguishing and it's capable of acting as a badge of origin. And in my submission, that's the touchstone for each of the criteria under Section 1. What is the point of Section 1? It's to enable only those signs which are capable of acting as a badge of origin across their scope, including any scope of variation. And that's why a sign ought to be clear and precise. And we have that here. So just working through the three conditions. Firstly, there is a single sign. It's the sign as shown in the visual representation and as described, gold oval in colours of gold and black. Now those are different shades of gold as one works through the shading. One could argue that there's no true black, but there's black shading as part of the mark to show the embossed visual effect in 2 dimensions.
Just before we get into the details, do I understand you to say that the subject matter of the registration is limited to what we see in the visual representation?
Not exactly, my lord. I would say that the hue could change, but keeping the contours as shown in the visual representation. So if one were to see the mark in the wild, as it were, it may not, and I believe my learned friend accepted this, there may be a change of hue.
Well, hold on. What happens in use is neither here nor there. What we're concerned with is what's on the register. Of course, any trademark can be used in all kinds of different ways in use, and as Mr. Mallage pointed out, when one comes to the non-use provisions, allowance is made for that. But the question we're concerned with is what's on the register. So it is your client's case, if I understand from what you just said to me, that the registration is not limited to what we see in the picture.
It's limited to the figurative mark as shown, but there may be variation in hue of the gold. But the contours of the mark and the scope of protection are limited to the contours of the figurative representation as it's set out in the picture, as it's set out in the visual representation.
So let me see if I got that straight. You say it's limited to the figurative mark, but the hues may vary. Did you just say only the gold, or only the black, or both, or everything?
It may be the gold and it may be the black, but in every case, the general contours of gold and black would follow that which is shown in the visual representation in my submission. So one wouldn't...
The gold can vary, the black can vary. What about the silvery tones? Can they vary?
Well, the silvery tones, in my submission, I'm not sure if one would call them silver per se, rather than variations of shading or of black and gold hues.
Well, when I looked on it electronically, it seemed to me that there was some silver there, and you see that illustrated in Mr. Mallage's skeleton argument, page 93, the picture that's bottom right-hand corner.
Sorry, was that page 93, my lord?
Yeah. It's annexed to Mr. Mallage's skeleton argument.
Annex 2, well, in my submission, there's a limited help that one can get from Annex 2 because when the readers, so I'm using that term to refer to each of the three groups of person that we're interested in, when they're looking at the register to either see what the scope of protection is because they're an economic competitor or because they're assessing validity or infringement, they're not going to be doing the type of exercise that Mr. Malinich has done in terms of taking individual parts of the visual representation and blowing them up and then pointing to that and saying there's silver.
But I simply was using that as a reference to illustrate what I was talking about. Because what I did was I looked on the electronic register, and which is the official entry, and I looked at the image on screen. And when I was looking at it on screen, one of the advantages of looking at it on screen is that it appears slightly larger than it does in your skeleton argument, which is not your fault. I'm not being critical. You cut and pasted a screenshot, and that's fine. Nothing wrong with that. But if you look at it on screen, it gives you the advantage that it is a little larger. And to my eye, there was some silvery tones in there, and I was just simply using Annex 2 to illustrate where one finds them.
Of course, my lord. I was just making the point that one has to be careful with Annex 2, but I take the point about looking at the registration as it appears officially electronically. And in answer to my lord's question about the silver...
Just see where we're going, because it's worth teasing out why this is worth discussing. And I think you're absolutely correct to start with the registration. I think that's fundamental to this opinion. But you see, one possibility, and there are others, but one possibility is that what we do is to interpret the registration as being limited to what is shown in the picture, and we treat the words as merely being descriptions of what is shown in the picture. And you see, if that were the correct interpretation, the objections to the validity of the mark would fall away, because it would be a single sign and it would be clear and precise. But of course, as it is always the case in these types of cases, it very much depends upon the stance of the applicant or the proprietor, because in most of these cases, what one sees is that the stance of the applicant or the proprietor is that the last thing they want is to be limited to the picture. On the contrary, they want a broader monopoly. So, with the benefit of that explanation, what's your client's position?
My lord, I appreciate that explanation. I would query whether, in all cases, the applicant is always looking for a broader monopoly or a more unclear monopoly. I don't think one can always impute that intention into what the applicant or proprietor is doing in these kinds of cases.
It's not a question of subjective intent. That's a pejorative way to look at it, and you're right to correct me on that. One has to look at it objectively, but nevertheless, that's the effect of the stance. I mean, take the Dyson case, where it was actually very clear, because on the face of it, the registration was what's shown in the pictures. But Dyson said, oh, no, we don't want to be limited to what's shown in the pictures, and that was their undoing.
So in my submission, the reasonable reader of the register would see the mark to be limited to the picture, save that there would be variation in hue. They wouldn't just see as a point of principle that the written description is something that can be notionally struck through or doesn't help.
No, it's a question of it not struck through, but interpreted as simply describing what we see.
My lord, in my submission, the reasonable reader would read the registration in that way. They would see that they're consistent. They would see, as the judge says, that the written description isn't telling one very much more than the picture is showing, and therefore the focus would be on the visual representation, such that the reader would say, this is what I see and this is the scope of the monopoly. And
sorry, can I take this in stages?
Sure.
So you said that the the registrations for the representation, including all the variations in shading, as it were. So, for example, just take the letter B, the first letter B. It's lighter on the left-hand side than the right-hand side. You accept that the registration is limited to that particular feature.
Save that the hues of the shading.
Well,
can
let me just
change.
leave the hues aside for the moment. The variations that one sees in the picture are the extent of the registration sought.
Yes, my lord.
The lettering is in a certain style. The letter E is a particular stylistic form of the letter E. You'd accept, would you, that the lettering in the registrations for lettering in that precise form?
My lord, yes. And that doesn't cause difficulty in practice because one could have Babek in the circle and have a highly similar mark, and we say that would obviously infringe.
Yes, obviously,
but for the purposes of saying what the registration is and the scope and the level of generality, the level of abstraction, as my Lord Justice Arnold put it, we would say the level of abstraction is as one sees in the visual representation.
Were you to have a valid registration simply for what we see visually represented, as you say, downstream, if somebody produced something that wasn't quite that but was similar, that doesn't mean they wouldn't be infringing.
Indeed. And the difficulty here is, of course, at the relevant date, we had to indicate a colour. I accept that the description of the mark goes further than that because there's a description of the embossing and of the oval. But if one were to just have the mark without the indication of colour, then it would be in my submission clear what the level of abstraction and the scope of protection is. And in my submission, that's not rendered unclear the moment one then adds, in this case, it can do, and I'm going to come on to the relevant test as to what's permissible and impermissible. But in this case, the mark isn't suddenly rendered unclear or a sign in a multitude of impermissible forms just because one has gold and black in the description.
So if the lettering in the description, the reference to Babek writing, is meant just to describe what appears in the picture, which you accept it does, if the description in words is simply meant to describe the picture, variations in light and shade that you see in the picture as they are there, what is it about the hue that makes you say that the written description goes beyond what you see in the picture?
Because in my submission, the words gold and black could cover some variation. It's not to be restricted to the certain Pantone colours that are shown there. And to require an applicant to do that in my submission would be wholly unworkable.
But is that not a slightly different question? The question I think we're on at the moment is not whether something else would be unworkable, but whether, in the context of this registration, really what you're getting registered, or what your registration is for the picture, with the words gold and black simply descriptive of what we see in the picture.
In my submission, the variations in the general shading plan, as it were, the general scheme of shades would be as shown in the picture, but it can extend to variations of hue as long as they're adhering to that plan. I've described them in my note as hues of black, where the hue should be, and hues of gold, where the logo shows gold, but the general contours of the mark being the same and being defined precisely. So in my submission, a reasonable reader of the register wouldn't think that we were claiming Babek with the colours reversed, so black where the gold should be and gold, and vice versa. They wouldn't think that. But they would think, well, the scope of abstraction can cover other shades, as long as this general scheme is adhered to. That's my submission.
Can I ask you a slightly different question? Because you referred rightly, I think, to the question of the level of abstraction. And one can understand how that works with a word mark. One can understand that with a device mark that is being registered purely as a device, in other words, with no colour element or claim. But how does it work with a picture like this? Surely there is only one possible level of abstraction, namely it's what we see in the picture.
My lord, one can look at it that way. In my submission, there is an analogy to be drawn with the device in black and white covering all colours. And it's this, that for a device such as this, what you see in the picture limits you to a particular scheme, as I say, but there is some room for variation within that scheme. There are the examples in my skeleton argument where my lords may recall I draw the yellow sun, and I say that in my submission that can cover any sort of colour or hue of yellow, as it were. And then one has the Tesco and the Coca-Cola marks in the judgment that my learned friends take issue to. And there's a
so just to understand, relating that to to levels of abstraction, on your argument, you say the level of abstraction is yellow, rather than any particular shade of yellow.
In the yellow sun example, yes.
In that example.
For a figurative mark of
Yes.
that kind. And the reason I say that is because it reflects, and I'll move on, if I may, to develop this more fully, but it reflects how the public and the relevant parties for the purposes of Section 1 would see and interpret marks psychologically. And in my submission, figurative marks of this kind are very different to colour per se marks, because a consumer, an economic competitor, or the relevant authorities will see the logo, to use a less formal term. They'll see that logo as designating origin, whereas colours normally are properties of goods. So, my lords, I think that probably covers why I say that there is a single sign, and also that there's clarity and precision. I appreciate we sort of run those two together, but I think that covers both, unless my lords had any further questions on condition 2, just looking at the mark in the face of the register. And then condition 3 in my submission is simple. This is an axiomatic kind of mark that is capable of distinguishing goods and services of one proprietor from those of another.
It's not suggested that there's any problem with condition 3.
Yes, my lord, I was just running through them all for completeness. So in my submission, this is plainly a mark that is clear and precise enough that it can be graphically represented in accordance with the Hacon criteria. That's the common sense result, and my learned friend Mr. Malinich referred throughout his submissions, I think, to the real world, a real world interpretation of the register, or this would be a real world reading in rather than a graphical reading. And in my submission, that's exactly right. And if one takes a real world reading with a good...
Well, the point he was making, as I understood it, was a slightly different one, which he was suggesting that what we see here is a 2-dimensional representation of a 3-dimensional object.
Well, my lord, I don't accept that submission. I'll go on to explain why.
I'm not surprised to hear you say that, but that's the context in which he was making that point. So I think one's got to be a bit careful about what he meant about real world. That was what I understood it to mean.
I'd misunderstood him in that case, my lord. But the point remains in my submission that one does have to look at these kind of questions and these kind of policy decisions with real world outcomes in mind, and as I say, with a healthy dash of common sense. If this registration isn't clear and precise enough to indicate origin, and I say that because that's the ultimate purpose, as I say, of Section 1, then one does wonder what a proprietor would have to do to make the cuts, especially in circumstances such as this, where one does have to indicate colour. Now, in my submission, the learned judge's test gives that real-world, commercial and common sense outcome, but moreover, it's consistent with the legal principles underlying Section 1.1. And I believe my lords have in mind the test applied by the judge, but if I could just take you to the judgment at tab 6. And although the reasoning and the application to this case comes later in the judgment, the key part of the test is at paragraph 67. Sorry, it's paragraph 67 of Sainsbury, which is at bundle page 55.
Sorry.
I'm so sorry,
55 of the bundle. Yes, I see. Yeah.
we're in call 1.
I'm catching up.
Now, in my note, I've called this the capacity to distinguish test, and I've written out a caveat about what I mean by that, given that my learned friend says that this wrongly aligns condition 2 and condition 3. To try and avoid those sorts of arguments as to definition, because in my submission this isn't wrongly taking into account acquired distinctiveness or anything like that, I'll call it, if I may, the indication of origin test. And I'll try to do that rather than talking about being capable of distinguishing. So with that test in mind, going to Section 1.1. Now, my Lord Justice Arnold was quite right to pick us up on this, on the fact that in the judgment and then also in the bundles, the correct version of the section hadn't been included. And I hope my lords now have the hand up in it. I think it's tab 26. In my submission, it doesn't make a pertinent difference to either the judge's reasoning or my reasoning as set out in my skeleton argument. If my lords want some authority on that point, I can take it from Glaxo. The point is merely this, that the changes to Section 1 that were implemented in my submission were only codifying in statute that which the courts had already been doing in practice by the implementation of the Hacon criteria and the interpretation of graphical representation in light of the Hacon criteria. So there was no change in the law in the application of the law in my submission. It's just that the wording of the statute changed. As I say, I can take that from Glaxo, but I don't.
I think that's common ground. It's just that it's helpful to have the correct statutory wording in mind because it actually is less confusing, particularly on this question of the interrelationship between the different conditions.
Of course, my lord. I consider that it's more helpful in one way, although I personally prefer the updated statute in that it focuses on the 3 classes of people that one has to have in mind, and in my submission that's quite helpful. But my lord is quite right that we have to have the right version of the statute in front of us. So, although the wording's changed, the underlying point is that there has to be clarity and precision from the perspective of these 3 classes of people. And the policy underlying that, in my submission, one can take from the decision in Heidelberger. Again, I don't think this is controversial, but I just want to draw my lords to it so that it's firmly in my lord's mind as I go through the judge's test and why in my submission it's the correct one. So Heidelberger can be found at tab 9 of the bundle. And if I could ask you to turn to bundle page 177. So just to orientate my lords, and you can see this from paragraph 22, which has been sidelined by my learned friends. Here the court is summarising the 3 conditions: that there must be a sign capable of being represented graphically, and it must be capable of distinguishing. And then the court explains the reasons why one has to satisfy those 3 conditions. So at paragraph 24, the purpose of that requirement, this is the first condition, is in particular to prevent the abuse of trademark law in order to obtain an unfair competitive advantage. The court then, from 27 to 30, summarises the policy underpinning graphic representation, which on its face may appear a little Delphic. If I could ask my lords just to read 27 to 30 to yourselves. And then over the page, the court summarises and says, in those circumstances, in order to fulfil its role as a registered trademark, a sign must always be perceived unambiguously and uniformly, so that the function of the mark as an indication of origin is guaranteed. And then they go on also to explain the durability requirements. So the touchstone in my submission, and the underlying principle which is encapsulated by the learned judge's test, is whether the mark can fulfil its essential function as a guarantee and indication of origin, and if one's looking at permissible variation, then is it capable of fulfilling that function despite the variations it will, or across the scope of that variation? Is the public still seeing the same sign, and do they understand the scope of protection clearly and precisely, given the essential function of a trademark? And then section 1 as a whole in my submission is therefore making sure that only those signs that are capable of distinguishing consistently and in a precise way can make the cut. And the judge's test in my submission does that and protects the interests of the 3 relevant groups and of the trademark system as a whole. And this brings me again to the test, to the application of the test, to the theoretical examples that I give in my skeleton argument. And I chose those examples to get around the arguments that one can have if one is looking at registrations that are actually on the register, so the Tesco and the Coca-Cola marks. So if I could ask you to turn to that example, it's core bundle 1, tab 9, bundle page 100. And if I could ask you to read paragraphs 14 to 16, that's where I set out the reasoning and the distinction between the 2 examples.
And what's the distinction in your submission between these 2 examples?
The distinction, my lord, is that in the case of the red ball, the colour red in and of itself isn't an indication of origin unless one specifies a hue, because
Why is it different in the case of the sun? Why is yellow an indication of origin without specification of hue?
because there one's looking at the sign as a whole and focusing on the fact that this is a logo. And in
Sorry, so is the magical difference the fact that one is 2D rather than the other, whereas the other is 3D? Is that what makes all the difference?
no, my lord, that isn't what makes the difference. In my submission, the difference is a difference in kind between colour per se marks, colour and shape marks, and logos on the other hand. And in my submission, where one's looking at a figurative mark, and perhaps the sun example is perhaps a little oversimplified, but when one's looking at logos, it's the whole graphical, sorry, not the graphical representation, it's the visual representation of that logo that's guaranteeing origin. So
let's leave aside colours per se. I quite understand why you put that in those in a different category. You said there was a distinction between colours applied to a shape and colours in a logo. Well, why? What's the difference?
thinking about the different permutations that could arise with colours applied to shapes, then my example is perhaps a little inapposite, because there could be colours applied to shape where variation in the colour doesn't matter because of the distinctiveness of the shape. So
that is your real point, isn't it? A ball is just a generic ball. If it were some very special shape of 3D object, then the precise colour might matter less.
indeed, so that's why I say in hindsight a little bit of an inapposite example, because it's not saying that colour must always be specified for a colour plus shape mark, because it is a matter of fact and degree in fact. And that actually brings me on to a point that I ought to have raised right on the outset, which is, what is the standard of review? And there we do differ from my learned friend. We say that this is a question of fact and degree. It is akin to obviousness, because under the learned judge's test, one's looking at the variation and then saying, well, how does this affect, from the perspective of the three groups, indication of origin, and how they perceive the mark as indicating origin. As regards to my learned friend's test, and I'll come to the difficulties with that test in due course, but his test seems to be that one looks at essential elements, and then in determining that which is essential, you look at what is important for some standard of importance. And in my submission, that's even more of a factually based assessment. And that therefore we are in a scenario where one's looking at the lifestyle equities level of review. So the example that I put in my skeleton argument is saying this, that there is a relevant difference in the way that the public perceives signs as between colour per se signs in certain more simplistic instances with a non-distinctive shape, colour and shape marks, although in my submission, my Lord Justice Arnold was right, it's not invariably the case, and how the public would see figurative marks. And that's analogous with the practice of black and white marks being capable of covering marks in any colour. And also analogous with the situation whereby one can register a word mark, and that word being allowable in any font when it's in the wild, as it were. And that's because in the case of word marks, it's the word itself that's designating origin. And here in my submission, in the case of figurative marks, it's the figurative mark, or what I like to call more colloquially, the logo that the public see as designating origin, and not the precise hue of that logo. And although we say that the hearing officer in Sainsbury at first instance applied the wrong test, this is also a point that was made by the hearing officer in Sainsbury. If I could take you to that, that's the second authorities bundle, tab 22. And the relevant paragraph is paragraph 80 on page 465.
I'm sorry, I must be in the wrong place. Can you give me the reference again?
I'm so sorry, it's the second authorities bundle,
Yeah, I've got that.
tab 22.
Yeah.
And it's paragraph 80 on page 465.
465, sorry, that was where I went wrong. Thank you. Yeah, but then you go on in 81, he says it applies to every colour which is an essential characteristic, and how do you decide what an essential characteristic is?
Yes, my lord, I'll go on to deal with those issues as we see it in the essential elements or essential characteristic test. But
And look at the touchstone he propounds. If it were otherwise, the task of deciding whether two such marks were identical would be made impossible. So, I mean, again, no doubt you'll come to this, but what is the criterion for single sign? Is it the same as the identity of mark? Well, Mr. Malich's his first position is you can't have any variation at all, but his fallback is you can have a degree of variation that is encompassed by the test for identity.
my lord, now might actually be a convenient time to deal with this point. So, as my lords would appreciate, we don't have a respondent's notice, and I'm not going to stand on my feet and make respondent's notice type points with no sort of warning to my learned friend or to the court. In my submission, the judge's test is the correct one, and that one doesn't have to apply the identity test when determining whether a degree of variation is permissible or impermissible. In my submission, the judge's test is the correct one, because as I've already submitted, at its heart is the question of, are these variations capable of changing the mark, of preventing the mark from consistently across its scope indicating origin? Are the variations such that the scope of signs and the variations of sign can no longer function as a single trademark that is clear and precise? And I hope I'm not misquoting, but I believe my Lord Justice Arnold suggested when putting this point to Mr. Malinich that the identity test may be too narrow. And in my submission it is, because, for example, in a hue, as regards hue specifically, the members of the public or the relevant authorities may notice a change of hue. It may be something that's noticeable to them, but at the same time, they're not going to think this is a different trademark or this is a different sign, and I can no longer be certain that this sign is representing goods and services of the same undertaking. So when one is considering the initial step of, is this a mark that is suitable for protection as a trademark, then in my submission one would apply the judge's test, and then as a secondary test of, once one has identified that mark at a suitable level of abstraction so that you've got the fixed starting point for assessment, then one looks at identicality. But in my submission they are...
You accept you need a fixed starting point for assessment?
I accept that that's one of the policies underlying Section 1 and Condition 2 in particular, yes. But having a fixed starting point doesn't mean that there must be no scope whatsoever for variation.
Just to expand on that a little, in a particular context, you would say your fixed starting point was yellow, say. And the fact that yellow might encompass more than one shade of yellow would not detract from the fact that the starting point was simply yellow.
So,
sort of by analogy, no, I won't try any analogies. Go on, yes.
So, my lord, in the example that I give in the skeleton argument of the yellow sun with colour claimed yellow, that would be right. And again, with the sheep example, and to expand the menagerie, when I'm making these kinds of submissions at the registry, I sometimes use as an example a purple hippopotamus. Now, that mark registered for purple could be mauve or lilac or indigo, but that's all covered by a scope of purple. So your fixed starting point in that instance is the logo, the hippopotamus, in purple, and that's covering different hues. But in my submission, that isn't impermissible.
I think the purple, mauve, lilac, and indigo are quite different colours, as witness the use of quite different words to describe them.
My lord, they do represent differently, and it is always a question of fact and degree in my submission. If the difference were such as to prevent the mark consistently from designating origin, then that would be impermissible. In the case of a logo of a single colour of that kind, it would depend on the registration in my submission. But generally, in my submission, a change of hue would not harm the origin function of that mark, and therefore, under the judge's test, would be permissible.
There may be circumstances in which a colour, if you have purple, there will be circumstances in which you say, no, this colour is not purple. It's outside the range of purples. But as Mr. Malinich's annex sort of illustrates, you can have lots of shades of colour that all could be called gold. And then on your case, the touchstone would be gold, so be it that there might be different shades of colour within that description, gold. The fixed point would be gold.
Indeed, my lord. And when one is looking at how one characterises the level of abstraction, it's applying the judge's test to see whether the variation gets one so far away from what's seen on the registration, say, that one is then looking at effectively different trademarks and different designations of origin. And in my submission, it's important and valuable to have that kind of touchstone that can be applied to these different factual scenarios, whereas my learned friend's test seemed to bend in the wind, as it were. Sometimes there was one answer, and other times another as to what fell on the right side of the line. Whereas in my submission, what one does is apply the judge's test, which is consistent with the underlying policy, and one gets a sensible answer out of the mix. And it's quite difficult on one's feet to say, well, this would always be on the right side of the line, this would be on the wrong side of the line. But one can apply the principle set out by the judge, the principled test, in a systematic and logical way. So taking that as my positive test, as it were, and my positive submissions, I'd like to go on, unless my lords have any further questions, to ground one. Now in ground one, the appellant advocates for an alternative legal test, that of whether the colours claimed or indicated, as they must be in this case, constitute an essential element of the mark. And I'll go on to say why that's the wrong test. But first of all, the appellant makes a number of criticisms of the learned judge's capacity to distinguish test that I'd just like to deal with first of all. First, the argument that the judge wrongly elided condition 2 and condition 3. In my submission, it may be that the judgment could have been expressed a little differently, rather than expressing matters in terms of capacity to distinguish. But the mere fact that condition 3 talks about capacity to distinguish, and then a test to be applied as to whether a variation is permissible or not also mentions distinguish, doesn't mean that the two tests are being elided. And in any event, the judge kept condition 3 and condition 2 separate. Now, one can leave aside the academic debate as to the meaning and application of condition 3, which I understand to be settled in any event, and just taking what my learned friend says about condition 3, because my learned friend is saying that the conditions were wrongly elided, and to counter that argument, one can look at what my learned friend say about condition 3. So that's paragraph 14 of the appellant skeleton. So we're in core bundle 1, tab 8, bundle page 73. So my lords, we agree with that characterisation of condition 3. It's a permissive criterion to allow in non-standard marks that on their face at first blush might not seem to be capable of functioning as trademarks at all in terms of being able to distinguish. So it's a low initial first hurdle. Is this kind of sign, for example, the layout of an Apple store, is this kind of sign capable of distinguishing full stop? And although it comes last in the conditions, for a mark such as this one, in my submission one could easily take it first. We know this is a figurative mark, and as my lords pointed out, there's no dispute as to condition 3 applying in this case, so we can tick it off the list, as it were. And then the judge asked, given that this sign is capable of distinguishing goods and services of one undertaking from those of another, if there is to be variation in the hues of the sign, does that affect the sign's capacity to distinguish? So there's still very clearly two separate tests. And to get, as I say, to get around the difficulties and overlap.
Let's be careful. I don't think Mr. Malinich would necessarily. The point is, you only get to condition 3 if you satisfy conditions 1 or 2. That's why condition 3 is not an issue, because it's not their case that if you satisfy conditions 1 and 2, you still fail on condition 3. Their case is you never get that far.
My lord, I accept that point. I would still say that conditions 2 and conditions 3 are kept separate by the judge's test.
So they're individual and cumulative, yes?
Yes. And the judge didn't mix them up in my submission because he was asking a different question and the subject of the analysis was different. It was saying that let's look at the variation and not the sign, for one thing, and then saying, is this variation permissible in that it still allows, with clarity and precision, the sign to indicate origin? So that's why I say one can call it the indication of origin test rather than the capacity to distinguish test. So one isn't, by taking the judge's approach, sort of melding the requirements together. So unless my lords have any further questions on that point, moving on to Zinger and the argument that the learned judge fell into the same error as counsel for the claimant in Zinger. I can potentially take this quite shortly because I don't think it's now in dispute as to what the claimant in Zinger was advocating for, that the heart of the claimant's submissions in Zinger was that acquired distinctiveness came into play. And my learned friend showed you the Scrabble tile registration and the various permutations of that. And of course we all know, or at least most of us would know what a Scrabble tile looks like. And hence Mattel were arguing that, look, one ought to take acquired distinctiveness into account here, and that argument was rejected. But that's not what the learned judge in this case is saying. Because
why not? Because the entire argument was that the origin message was unaffected, as proven, so it was argued, by acquired distinctiveness.
My lord, I would disagree that the judge in this case took any account of acquired distinctiveness. He was looking at the mark.
There's two separate questions. One is what the judge did, and one is what the reasoning in Zinger is. And what I was asking you a question about was the reasoning in Zinger. So the reasoning in Zinger was, it was Mattel's argument that there was no impact on what you call indication of origin, and that the way in which they could make that proposition good, they said, was by demonstrating acquired distinctiveness, to which the answer given by both courts was no, because it's irrelevant.
My lord, I apologise for mixing that up and not clarifying what the arguments were in Zinger. As to the argument that indication of origin wouldn't be affected, in my submission that can't be right because of the examples that were given by counsel on the other side of the letters on different parts of the Scrabble tile, the different sizes of writing, my lords might recall from the judgment. But that same answer would result from an application of the judge's test here. And in my submission, the judge wasn't saying that to feed into a test of whether there is an effect on the origin message, there must be account taken of acquired distinctiveness. So that's the distinction in my submission between the judge's test and Zinger.
I'm sure it's my fault, but I'm not following. So let's try and take a little more slowly. The argument that Mattel was running in the Zinger case was they said, we can prove that no matter what variations you have in the presentation of the letters and the numerals, members of the public will still get the message that this is a Scrabble tile and therefore comes from us. And therefore, they were arguing that that showed that the variations were permissible because they had no impact on the origin message, which is the test you propound. To which the answer given by the courts, as I've just said, was no, it's irrelevant whether you can prove that members of the public would always get the same message as to origin.
My lord, my reading of what the claimant in Zinger was arguing for is that we can prove it as a matter of I think in that case, it was survey evidence,
Correct.
and in showing what actually the public perceive in practice, and in particular taking into account acquired distinctiveness of the Scrabble tile.
Yeah, so the idea was they would show respondents to a survey a whole series of variations of Scrabble tiles, some with large letters, some with small letters, some with small numerals, some with large and varying the position, etc., etc. And they were offering to prove that no matter what the degree of variation, the public would always get the same message.
So, my lord, in my submission, that's a material difference in kind from what the judge was doing here, because the judge was asking the question in the abstract, not taking into account how the mark might have been used in practice, and not taking into account actual public perceptions of the mark. It was asking the theoretical question as to whether the capacity to distinguish or origin message could be affected. And in my submission, that's the right test by reference to policy.
Theoretical question, how can origin ever be a theoretical question? I don't understand.
By that I mean there's no reliance on, for example, survey evidence as to what the public actually think. It's looking at the notional public and the notional relevant authorities as well, who are not taken into account if one goes to the public with a survey and says, what do you think of this mark and the variations to that mark?
There's a distinction on your case between an argument which says, if we took this to the public, they would say, it doesn't concern us, there's no material distinction. We can see this as a mark of origin. And evidence which says the public have spoken, and they've said that. Is that your point?
My point is that if one were to apply the test that the judge did, the capacity to distinguish test, to the mark in question in Zinger, then one can see just by the differences between the different variations in that case that one isn't looking at the same mark. And it's irrelevant if one were to then go and ask the public, oh, what do you think? Because the degree of variation is so great. And in my submission, going and saying, well, we're going to go and ask the public the question by means of surveys, means that one is feeding in questions of acquired distinctiveness.
Can I ask a slightly different question? Are you saying that the distinction is between acquired distinctiveness and inherent distinctiveness, and if so, why?
My lord, there's a difference between the two, because when one's looking at registrability, the mark won't actually have been used in practice, might not be used for some time. And in my submission, it's not necessarily even about distinctiveness of the sign per se. It's more, and this is why I think distinctiveness isn't necessarily a helpful way of putting the test. In my submission, the question is, if one were to change this aspect of the sign, would one see the same badge of origin or the same sign, if you will? Now that's a little bit of a circular way of putting it. I'm trying to put it in ways that don't call out distinctiveness, if you will. But it's asking the question, is this degree of difference so great that suddenly one is looking at a different badge of origin and a different sign? And as I say, the reason why in my submission one can't, although it may at first glance look quite attractive, the reason why that's a better test than just porting across the identicality test is because one might notice a hue, might notice a change in hue, but nevertheless still consider the badge of origin and the origin message not to be affected by that which is noticeable. I think that deals with what I was going to say on Zynga, unless my lords have any further questions. And then finally, the appellant argues, I don't think we have to go to it. My lords may, if you wish, like to have it open while I make my submissions. This is at paragraphs 32 and 33 of the appellant's skeleton. So tab 8 of the bundle. And it's page 81. They argue that the capacity to distinguish test is too permissive in that it would allow, they say, very broad variation in colour, and it would never require colour to be specified other than for colour per se marks. Taking that last point first, well, that's wrong, because in Sainsbury there was a colour and shape mark that was not permitted. So it's not right to say that only colour per se marks would need to have hue specified. And in support of the first point, the appellant argues taking the Tesco registration, which I don't really want to go into any great detail about, because there's the issue with whether one should look at the Tesco registration. But they say, well, looking at the Tesco registration, under the judge's test, even though that claims blue and red, it could also cover green and yellow or green and gold. Obviously that's wrong, because then there would be a conflict between the use in green and gold and what's registered. The registration is saying blue and red, and that can't conceivably cover green and gold or green and yellow. But in my submission, it's not enough to say, well, that test is too permissive, without saying why, or without saying what effect that would have on the trademark system as a whole, whether to the registration system or how one perceives trademarks in practice, or understands the scope of one's freedom to operate or the ambit of protection. So they say that this could mean that hue never has to be specified for logo marks.
Yeah, so this brings us back to what we were talking about earlier, and can I just ask another question about that? Because when one looks at the cases, it seems to me that one could draw a line in this way. As you say, let's leave Tesco out of the count, not least because it's not subject to any decision. But if we look at, on the one hand, Robert McBride, Calagas and Sainsbury, and on the other hand, the present case, one could say that there is a distinction, because what McBride, Calla and Sainsbury all have in common is, as you noted earlier, is their claims to shapes and an indication of colour. And particularly true in the McBride and Calla cases, perhaps a bit more debatable for Sainsbury, you can't say the sign is that which is in the visual representation, because the visual representation in itself is imprecise. By contrast, in the present case, given it's what you call a logo, or what's called in the application form a figurative mark, and I don't think it matters, you can readily say the sign is what we see in the picture, and the words are there just to describe it.
My lord, I do say that that's a relevant distinction between Calagas and Robert McBride's, where one had generic shapes effectively and a non-specified colour, and a case of this kind. Now, I don't want to stand here and say, because in my submission it's a matter of fact and degree, I don't want to say that in every single case with a logo what you see is what you get. I think it's slightly more nuanced than that. But I do submit that figurative marks do raise, they're in a separate categorisational class, if you will, to the Callaghan and Robert McBride type marks. And that the judge's test has the advantage that the results that it gives are in line with that distinction overall in my submission. So then moving on, if I may, to what my learned friends say that the test should be, and that's effectively ported across from the shape or other characteristic requirements in section 3 of the Trademarks Act. So asking quite a different question. And as I say in my skeleton arguments, apart from a to me more obscure section of the Act talking about plant varieties, that was the only place in the Act that I saw any kind of reference to essential elements. But if I could just take you to that. So this is at tab 27 of Authorities 3. And it's section 3.
Sorry, I've gone to the wrong place. Tab.
It's tab 27.
Oh, I have gone to the right place. I'm just looking. Yeah, I see. Yes. Yeah.
And it's 3 sub 2.
Yes.
A sign shall not be registered as a trademark if it consists exclusively of, and we can take it from the shape or another characteristic of goods which is necessary to obtain a technical result. So a very different part of the Act with very different underlying policy considerations. So here one's looking at, to take 2B, not allowing proprietors to, in effect, get a perpetual monopoly for that which ought to be protected by patents. So patents, a time-limited monopoly, which shouldn't be extended by saying, well, actually, I've also got a trademark for this technical result, because that would be contrary to the balance that patent law seeks to strike between monopoly and free use by competitors once that monopoly expires. And the reason I draw out the fact that this is a very different part of the Act and very different underlying policy is because it's incredibly difficult intellectually, at least from where I'm standing, to apply this test to variations and to considerations of registrability under Section 1. Because what does one mean by consisting exclusively of shape or other characteristic? What does one mean by essential elements in this context? It's entirely unclear. And my learned friends say, well...
Just staying here one moment.
Yes, of course.
Showing my ignorance of the law. Going back to your red ball example.
Yes.
Now, there the attempt would be to register for the red ball rather than just the ball. But the shape of the ball results from the nature of the good itself, doesn't it?
Yes, and then one could have, for example, there's the example of the Lego brick. And the shape of the Lego brick is designed to fit to other Lego bricks. Or one could have a shape or other characteristic that ought properly to be covered by design rights. And so the demarcation between trademark law, where one can have an unlimited monopoly for however long one wants, as long as you keep paying the registration fees, the demarcation between that and other monopolies granted by other types of intellectual property legislation, which are intended to be time limited for perfectly good and sensible policy reasons, the demarcation between those is the purpose of this section of the Act.
Yes.
But the difficulty here is, as I say, how one takes looking at essential elements of a shape or other characteristic. I accept it's not just shape. How one takes that and applies it to variations of a sign in the context of registrability. Now, my learned friends argue that the essential elements are those which are important, but that raises the further question, of course, of what important means in this context. And that was recognised in the Sainsbury decision by the learned judge. If I could ask you to turn to that. So we're back in Authorities Bundle 2, tab 23. And if I could ask you to turn to page 488 and to read paragraphs 55 and 56.
I beg your pardon, could you give me the paragraphs again?
Yes, of course, it's paragraphs 55 and 56.
Thank you.
So taking the two, and I don't want here to try and perfect my learned friend's test, but if one takes the two extremes, as it were, or the two choices put forward by the judge. So if it could be any element of the sign which makes more than an insignificant impression on the eye, then colour in almost all trademarks is an essential characteristic. And if that's right, if that's what important means, then in every single instance one is going to have to be having to specify hue. And for a trademark of this kind, one would then be having to specify a large number of Pantone numbers and or other indication. It goes further than that, because how does one with precision identify where one hue begins and another ends? Because in my submission, if one starts to require this level of specificity to elements of a trademark, then it just leaves room for further argument of, well, you say Pantone number X up to here, that's blending into Pantone number Y, but actually that's not what the visual representation is showing, or yes, you've specified that, but that actually goes broader and you're generalising now in the description from the visual representation. It's just a recipe in my submission for further pedantic arguments. And more fundamentally, it's not getting at what I say is the underlying policy of section 1, as I've already submitted, because one is just taking wholesale a test from another section of the Act designed to further different policy considerations and saying, I'm going to apply that, and I'm going to apply some level of importance, but I'm not going to tell you what it is. Well, to be fair to my learned, that's not right. My learned friend does say, I think it's that which would go unnoticed by the average consumer. And we say that's not right, because again, it's giving the judges a high level of degree of importance, in the sense that it's anything that makes more than an insignificant impression on the eye. And in my submission, that would lead to having to give a degree of specificity which would be unworkable and not in line with policy. Because it would mean having to specify every single hue, for example, to the nth degree. So that was what I was intending to say about the test that's advocated for by the other side. Unless my lords have any further questions.
You're moving on from ground one, are you?
There was just one matter for completeness under ground one, and that was the appellant's argument that the judge erred in failing to take account of the word claim rather than indicate. There appears to be...
Well, I think Mr. Malinich accepted in the course of argument that wasn't significant.
My lord, yes, that was all I was going to really say about claimed versus indicated. It's semantic pedantry in my submission.
Okay. Just before you leave ground one, can I just ask you one further matter, which probably doesn't matter, but while it's in my mind. There was reference earlier to Rule 3.5,
Yes.
Which is set out at page 18 of which is skeleton, page 18 of London.
Yes, my lord, it also should be in your authorities as well.
It is it?
Yes, one can take it from... I'm just double checking.
Yes, it is.
Yes,
30.
tab 30.
And that's as it was originally framed. I think if you look at the judge's judgment, paragraph 22, where he's quoting Lord Justice Kitchen,
Yes.
he quotes Rule 3, and I think he's quoting the version of Rule 3 which was actually enforced in 2008-2009. And if you look at 3.5, it is actually slightly different. It says the colours making up the mark shall also be indicated in words, and a reference to a recognised colour code may be added. So the reference to the colour code in some sense is optional. If you're going to indicate a colour in words, but don't add a colour code, how do you do it?
Well, my lord, I would say that one indicates it in the same way that we have, that one says the colours claimed or the colours indicated, and then one simply states the colours. The rules aren't prescriptive as to how one does it.
To put it another way, as I said, I'm raising a point that could conceivably be helpful to you, though probably not. If you actually wanted to go beyond purple, you would have to use a colour code, wouldn't you? I mean, how do you otherwise distinguish in words between one shade of purple and another?
Yes, my lord, if one wanted to claim a specific subcolour, as it were, or a specific hue, then in my submission, I don't want to say one would have to, but it seems that a sensible course of action would be to identify using a Pantone code.
And just a further thing, I think it's suggested, well, the solution back in 2009 when the application was made would be to say the colours are as indicated or something. Is that indicating it in words? Maybe it is. Are you indicating the words, the colours in words?
Colours as shown in the visual representation, or the colour reproduction to use the example.
Yes, my lord, I think that would be one way of indicating the colours in words, but it wouldn't be the only way, and the regulations aren't prescriptive in that sense. And the regulations could have been. I mean, if one looks at rule 3, sub rule 2,
yeah,
there is great specificity as to the sheet on which the mark is to be reproduced. So when the rules want to be very specific and precise, they can be. And if the intention was that for any kind of mark that's covered by 5, one has to specify, for example, Pantone codes, then in my submission the rules would have said so, given that one is descending into A4 size paper with specific centimetre requirements.
Well, yes, but on the other hand, the rules don't say that if you're claiming colour per se, you have to put the Pantone in, but we know from decisions of the Court of Justice that you do.
No, my lord, that's a fair point, and I thought maybe a point that's put to me if I were to make that submission, but my overarching point, and the reason I pointed to the requirements under section 2 is that in my submission the intention of rule sub 5 is to be non-prescriptive. Of course the courts can then interpret it as they see fit, but there is nothing to say that one must indicate only by reference to the visual representation and nothing else will do. The rule is more flexible than that, and in my submission that's a benefit of the way that the rule has been drafted, because it allows one to interpret the rule by reference to different types of marks that raise different kinds of considerations, so colour and shape or colour versus figurative marks, which, as I say in my submission, is a relevant distinction in the vast majority of cases. So moving on to ground 2, unless I can assist my lords further on ground 1. So that can be dealt with, fortunately, much more briefly. It's pursued in the alternative to ground 1, and it relates to the judge's application of the capacity to distinguish test to the facts of this case. I'm going to ask you first, so you have the point my learned friend is making, if I could ask you to turn to First Core Bundle, tab 8. Page 86. And it's the allegation here that the judge failed properly to consider the range of hues, shades and gloss matte effect falling under the verbal description gold or black, and the effect that such variation would have on the distinctive character of the Babek mark. And the appellant goes on to cite some paragraphs in support of that argument. Although, as explained in paragraph 46, at paragraph 93 of the contested decision, the judge does refer to the different Pantone hues of black and of gold that have been identified by the appellant. So in my submission, if one's looking at the text of the decision, the learned judge did clearly have the different range of Pantone hues in mind. And if I could just take you to that part of the decision. So that's over on tab 6 of the same bundle, page 64. And in my submission, not only did the learned judge have the arguments and the Pantone colours put before him in mind, he gave them more than glancing consideration, because he says, looking at these as presented at the hearing, I am not sure that they could all be described as gold or black, but this is not to the point. So the submissions are in mind, and the judge considered the range of Pantone colours put before him quite carefully.
Do you understand what he means by that? Because certainly if you take the golds, most of them have got the word gold in their names. Or if it's not gold, it's golden.
I think what the judge is saying here, that although they are described as gold by the Pantone description, one could perceive them. My reading of this is the judge is saying that one could perceive them as off gold or a brownish hue.
Maybe he simply meant not gold to his eye.
He may have meant that, and of course
It's rather subjective, isn't it?
different people see colours in different ways, my lord, of course. And then the appellant goes on to argue that, well, the judge merely dismissed the arguments about Pantone shades in one paragraph, and that's the conclusion at paragraph 101. But in my submission, there's nothing really in that point. The judge took the arguments into account and rejected them. That he did say briefly in my submission is neither here nor there, and there doesn't appear to be any real error of law or principle that's been identified under ground 2. So as I say, that's ground 2 dealt with fairly shortly. Subject to my lords, I'll move on to ground 3. So ground 3 again in my submission is best taken by taking my lords through the judgment. And this argues that the learned judge erred in treating the categorisation of the mark as a fixed starting point. And then that by taking that starting point, there was an alleged inconsistency between the verbal description and the categorisation that the learned judge failed to take into account. And as I explain in my skeleton argument, that suffers from 2 fatal flaws. The first being that the judge didn't treat the categorisation as a fixed starting point. The second being there is no conflict between the category of mark and what is written as sensibly read by the reasonable reader. So taking the first point first, again I'll proceed from the judgment and the paragraphs relied upon by the appellant. The first of those is paragraph 50 on bundle page 59. And here we say the judge is applying the correct test. He's not misdirected himself. He's not treating categorisation as a fixed starting point, but it will often be the most useful starting point, and it's a factor to take into account. The appellant then points to paragraph 73.
Can you just help me? What in your submissions does the judge mean when he says the judgment of CJE and Hartwell implies there's no such rule of law? First of all, what do you understand the rule of law that he is talking about there? So when he says no such rule of law, what's that referring to?
In my submission, that's referring to, he says, although in Glaxo, the analysis took the categorisation of the mark as a colour per se mark to be a firm starting point, but he's saying that that wasn't being established as a rule of law. It wasn't a principle that one must take categorisation as a firm starting point.
Right, and so what, therefore, is he meaning? So there's no rule that it's a firm starting point. But what does that mean? Does that mean you're free to disregard it, or what?
Yes, my lord.
Because
Oh,
I would suggest to you, and I would invite your comment, that if that is what he means, then Hartwell is authority for the opposite, which is that you are bound to take it into account, and if there's an inconsistency with the description, that's fatal.
No, my lord, I'm not saying that. No, in my submission, the judge there is not saying one has to disregard it. But my reading of paragraph 50 is that one doesn't have to take the categorisation of the mark as a firm starting point. There's no rule of law that it has to be your starting point, and that it needs to be the touchstone of the analysis. There still has to be consistency between all parts of the graphical representation. But I don't...
So you would accept there has to be consistency?
My lord, yes. And I'm not suggesting that the judge here is saying one must completely disregard categorisation.
So, in summary, your submission is that no matter language, because any judgment, one can always criticise language after the event. We're all only human. But as I understand it, your submission is that the message is, first of all, you are required to take categorisation into account. Secondly, there must be no inconsistency. Thirdly, but that's as far as it goes.
My lord, that's what I say that the judge is saying here. So when there's an argument put against the judgment that the judge took the categorisation as a fixed starting point, in my submission that's just not right, taking into account paragraph 50. And I'll go and look at the other paragraphs that are relied on by my learned friend, but at no point is the judge saying it is inadmissible.
It's a semantic debate, because once it's accepted that you have to take it into account, and it's accepted there mustn't be any inconsistency, what does the word fixed add or detract? I mean, this is not necessarily criticism of you. I appreciate you're responding to an argument from Mr. Malinich on this ground, but what is the magic in the word fixed?
So my understanding of the underlying point that ground 3 is trying to make when it refers to a fixed starting point, my understanding of that argument is that the appellant is saying it was impermissibly taken as a fixed starting point, such that the judge had in mind this is a figurative mark and this is a mark in 2D, and that he thereafter erred by placing too much weight, I think is the argument, on that categorisation, such that if he hadn't done so, he'd have seen that the word embossed must be referring to a 3D mark, and he would have given some weight to that inconsistency. I think that's what ground 3 is trying to say.
So, rephrasing what you just said, to check I've understood it, your understanding of Mr. Malinich's argument, and you're rebutting it, of course, your understanding of the argument is that the judge has used the categorisation, as it were, to trump any inconsistencies that might otherwise be apparent. And you say that's wrong. He hasn't done that.
Yes, my lord, and I can make that good by pointing to the paragraphs that my learned friend relies on. But I think that's the nub of the argument. Yes. So the first paragraph that's relied on is paragraph 73 on bundle page 62. And this is where the judge says, as of that date, the competent authorities and the public were told that the proprietor intended the mark to be a figurative mark. Clarity and precision must be assessed accordingly. But paragraph 73 is the conclusion of a section of the decision that's discussing the effect of Brexit. Now, the learned judge was concerned about the difference which my lords picked up between the register in the EU IPO and the UK register, the fact that as the mark is on the register in this jurisdiction, there's no categorisation of mark. And the judge was concerned that this might affect the analysis because members of the public and economic competitors might not go away and look at the EU IPO register that this mark is derived from, but the relevant authorities might. And the judge was concerned because, to my recollection, in all of these cases, one just groups the three people together and looks from the same eyes. Now, the judge was concerned here that actually there might be a divergence between what the relevant authorities might look at and the other groups covered by section 1. However, in paragraph 73, the judge is saying we don't need to concern ourselves with that because at the relevant date of assessment, we're looking at the register with the mark put as a figurative mark and categorised in that way. So we don't need to trouble ourselves with that difference. That's all the judge is saying here. He's not saying it's a figurative mark and that trumps inconsistency with verbal and written description. And then moving on to paragraphs 83 to 85, unbundle page 63. Again, this is relied on by my learned friends as saying that the judge erred with this fixed starting point. But in fact, in my submission reading these paragraphs, the judge did nothing of the kind, and he didn't err in failing to appreciate an inconsistency, because there is no inconsistency. The way in which the figurative mark has been rendered is such as to show areas of light and shadow, light and shade, which show an embossed effect on a 2D figurative mark, a 2D logo. And as the judge says, this has been a well-known effect in visual art for many years. So that's all that's going on in my submission when the description is talking about embossed and embossing. The judge didn't err in failing to see an inconsistency because there wasn't one to see. So then, moving on, if I may, to ground 4, it's a little tedious, but in my submission, again, that the best way to rebut ground 4 is to go through the judgments. And here the allegation is that the learned judge erred in failing to apply the principle that where a pictorial representation and verbal description are provided, neither one has precedence over the other. Now, I accept that the judge let's look to the paragraphs which my learned friends take exception with. So, if I could ask you to read paragraphs 100 and 101 on bundle page 65. Again, the learned judge had the correct principles in mind and he sets them out. In my view, the reasonable reading of these paragraphs is that the judge was taking all parts of the graphical representation into account. Yes, he says the written description doesn't tell you very much more, but that's because in my submission here there's consistency, and where there's harmony between visual representation and written description, there isn't really much more to say. And in the counterfactual, if there had been an inconsistency, so say the logo had been, the figurative visual representation had been entirely silver, different shades of silver, no gold at all, but the written description said gold, then under the judge's reasoning there would be much more to say about the written description because they'd be clashing. But here it's perfectly legitimate for the judge to phrase things in the way that he does because there's consistency. And as I say, how much more can one really debate a consistent visual representation and written description? Moving on to ground 5. In my submission, this really has two subgrounds, a 5A and 5B, if you will. So ground 5A, that the judge erred by taking into account other marks in the register contrary to Hollington and Hewthorne, and ground 5B, that the judge erred in taking into account the effect of a finding of invalidity on other marks in the register. I can deal with...
Yeah, it's not a Hollington and Hewthorne point, as Mr. Malinich acknowledged. It's a more fundamental point, which is the well-known proposition that the state of the register evidence, even when the register is in evidence, which it isn't in this case, is irrelevant. And that goes all the way back to Madame trademark and subsequent authorities ad infinitum. And I assume you wouldn't dispute that.
My lord, I don't. What I would say is that one can notionally strike out the parts of the judge's judgment that deal with the Tesco and the Coca-Cola mark, and one would come to the same result, that the same legal test is still relevant, and the reasoning that leads up to that test is not dependent on the state of the register and what's on the register already. But I would say, my lord, that if the test advocated for by the appellant would have the effect that a vast number of marks, or a number of marks that have been causing no harm that are on a register, that are such that economic competitors can see their scope of action, that consumers can see those marks as a badge of origin.
A, how do we know that? And B, why does it matter? I mean, in the result, after the Supreme Court's decision in Skykick, now established that a registration of a trademark for all computer software is liable to be bad. There are probably millions of trademarks on the register that are bad as a result of that. So what?
My lord, I'd take it as a slightly different point, in that, as a matter of practicality, there are marks on the register. I can't ask my lord to look at what's on the register, but assuming there are marks on the register that claim colours and are figurative marks, and in practice there have been no issues caused by those marks such that they are able to function as a badge of origin.
How do we know there are no issues? For all we know, they've been used to gain unfair competitive advantage because trademark proprietors have used the ambiguity in the registrations to claim more broader rights by way of threatening letters than they would otherwise have been able to do. How do we know?
My lord, in my submission, if one's looking at marks such as this, where it's a simple matter of colour being claimed alongside a colour figurative representation, then it would be very difficult for somebody to claim a broader scope of monopoly, or that there's some ambiguity such that they can befuddle their competitors into thinking that that scope of monopoly is not as stated on the register. So that's one point I would make about unfair advantage. And if, under my learned friends test, even marks of this kind are objectionable, then in my submission one would expect that to have filtered through by now. But my point isn't so much about marks that are on the register or the state of the register. It's more harking back to my earlier submissions under ground 1 and the ultimate purpose of section 1. But in my submission, ground 5 is irrelevant in any event, because the basis of the judge's reasoning was not, goodness, what could happen to the register if this mark were to be found invalid, or if I were to apply a different test. The judge summarised the relevant authorities, applied the relevant principles, and came up with a test that in my submission is sound. So my lord has my submission as a policy consideration. In my submission, if otherwise unobjectionable marks would be swept away by this, in my submission that is support for saying that the judge's test is the correct one and my learned friends isn't, but I don't have to rely on that submission or make that good in order to say that the judge's approach was the right one. And nor do I need to make that argument in order to say that ground 4 really doesn't matter in and of itself. One can take away the objectionable parts of the judgment, the references to Tesco and Coca-Cola, and still come to the same result as my submission. So unless my lords had any further questions on ground 5, I was in...
Sorry, you said there were 2 parts to it, so you dealt with the other registrations of Coca-Cola and Tesco. Was there another part?
Oh, there was, my lord. I thought we had traversed that in our discussion, the effect of a finding of invalidity on other marks on the register.
You're right, understood. Sorry.
And I made the point that if one interprets section 1 in a perverse way, such that otherwise unobjectionable marks suddenly at a stroke become invalidated, then that is in my submission, a second order reason why the judge's test is a correct one and my learned friends isn't. So finally, my lords, ground 6. And in my submission, this is very much the final ground in terms of its relative importance. It ties into the judge's conclusion that the reader of the register is not an anxious pedant. And in my submission, they shouldn't be notionally construed as though they were. And the ground 6 points that are raised by my learned friends are very much anxious pedant points in my respectful submission. And under ground 6, my learned friends take these points, but there's no real analysis as to how some alleged inconsistencies in the judgment may render the entire decision and its conclusions unsafe or amenable to reversal. But in any event, if I can just take you through ground 6 quite shortly. The first alleged error is that the judge found that there was no true black shown, but nevertheless found there to be no inconsistency between the pictorial representation and the claim to black. Now, query whether one can ever have true black outside of a laboratory, given that black is a pure absence of colour. But in any event, the rebuttal to my learned friend's arguments is probably best taken from the judgment at paragraph 92, page 64. Where the judge says, Iceland's next point is that there is no true black shown. Considered over literally, that is true, but there is no inconsistency. A reasonable reader, I'm pausing there in my submission, that's how we should interpret the registry. A reasonable reader would understand that what is meant by black are the dark shadows, which cannot sensibly be described as gold in colour and are approximately black. So there's no inconsistency, my lords, between saying there's no true black shown and there's no inconsistency. It's explained by the judge's reasoning at 92. The final point made under ground 6, let me just remind myself of the exact wording. So this is a similar point, that the learned judge found that there are colours in the visual representation which are not strictly either gold or black, but erred by finding that this did not lead to inconsistency. And as I say, in my submission, the best response to this is the judge's conclusions at paragraph 102 and 103. And the judge is making the same point, that one has to look through the eyes of the reasonable reader of the register, taking into account both visual representation and the description. And the reasonable reader will, in my submission, understand the registration in the same way that the judge does, because they're not an anxious pedant. They're somebody who's going to read the register with common sense. And in my submission, on any common sense view and reading of the register, the sign-in issue here is a mark, a protectable mark, for the purposes of section 1. Unless my lords have any further questions, that concludes my submissions.
Thank you very much, Ms. Dixon. Mr. Malovich.
Thank you, my lords. Just in the order in which my little friend dealt with them. So it was significant that she accepted that the mark was not confined to the to the hues that were shown in the registry. It's in the representation.
So on that, can I just ask this question? Would you accept that the correct interpretation of the subject matter of registration is, at the end of the day, a matter for the court?
I was going to address you on the standard of review.
No, that's a separate question. That's a separate question. So let us assume, for present purposes, that the judge's judgment is flawed, and therefore this court has to reconsider the matter.
Yes.
All right.
Then it's
So we start from carte blanche. Then the interpretation of the registration is a matter for the court. Yes.
Yes. You wouldn't need to.
And therefore, it would be open to this court. Would you accept? I'm not predicting what we will decide, but it would be open to this court to reach the conclusion that the registration is limited to what is shown in the picture. You would say that would be a wrong interpretation, and you would pray and aid in support of the fact that that's not the respondent's case. But would you go so far as to submit that we couldn't reach that interpretation?
You would be altering the visual identity of the mark post-registration.
That's a different question. I mean, that's the point I already mentioned. You would say that's not the correct interpretation.
Yeah.
My question is a different one. Are we constrained by the submissions of the parties?
If you had to interpret it one way, yeah.
Because, I mean, is it not like interpreting a contract or interpreting legislation where it's well established the court is not constrained, or indeed a patent claim, the court is not constrained by the submission of the parties? This is frequently the case, particularly in patent cases, that the court arrives at an interpretation which is neither contended for by the claimant nor that contended for by the defendant, but is somewhere between.
Well, I hope either my learned friend or I have attracted your view, your thinking to some extent.
Would you dispute that it's open to the court to arrive at its own interpretation?
I can't dispute that.
Right. That was all I was asking. Thank you.
Yeah. I mean, as I say, I hope that one or other of us has persuaded you to take their view. So far as this, the acceptance that the hues are different is not something that is just that my own friend accepted just under pressure. That is the basis of the red ball example as well. The distinction between the red ball and the yellow sun that's in as a skeleton is exactly a distinction between red ball, where hue has to be given, and yellow sun, where it doesn't have to be, and it doesn't have to be, and can cover numerous hues, even though it's a very simple little diagram.
Well, I take your point about that, but as you heard, we explored with Ms. Dixon the question of what the true distinction is, and what would be your response to the proposition that there is a distinction between, on the one hand, a registration such as those we see in McBride and Calla, where the picture simply shows shading and colours denoted by words, and therefore you can't simply rely upon the picture. And a case like the present, which is, to use one term, a figurative mark, to use another term, a logo, where it is possible to simply confine attention to the picture. And appreciate, of course, we can't ignore the words, but it might be suggested that that's the distinction.
When I think to my learned friend whether it was possible to say just look at the picture in relation to a Calagas type of mark. My submission would be why can't you? You could potentially do that. It could stand on its own.
How so? Because the only way you know what the colours are is by reference to the words.
Well, I think because those are older marks, maybe
but so what?
So the shading indicated a colour under that old scheme. So cross-hatching meant yellow or blue, whatever it was.
But it never indicated a precise shade, that's the point.
No, it never indicated the precise shade. So you couldn't, in relation to older marks, do that. But that's not the current situation. I mean, the current position is Baby Bells, an example. You've got the actual representation there. And you say, look at that. But I'm not sure whether that actually assists with
Well, I
dealing with
understand
the
your
mark
point
that's
about
sitting
baby
on the
milk. I mean,
register.
that's a slightly equivocal case because, on the one hand, if we're looking at it with this distinction in mind, you could say it falls on the right side of the line because you can just look at the picture and you learn the hue from that. But on the other hand, it was pretty, my understanding is that Baby Bell's argument, Fromage Bell's argument, was no, it was not limited to what was shown in the
I'm
picture.
trying to recall.
And the possibility of it being interpreted in that way doesn't seem to have been canvassed enough.
I mean, bringing back to this case, if a party has said to the court, in writing and on your feet, this is meant to cover different hues, and if the description has been sitting there on the register since 2009, telling people, there's a great deal of uncertainty about it in terms of the hues, then, in my submission, there would be no basis for interpreting it as being confined to the colours of representation.
But isn't this where what the judge says in paragraph 73 comes into focus? Because he makes the point that we have to view matters, as you just rightly said, as at 2009.
Yeah.
And as at 2009, what we have, as we see from the supplementary bundle, is an applicant acting in person, and they fill in the type of mark figurative, representation of the mark attached, and then they put in indication of colours and so forth.
Well, yes, but they put in more than indication of colours.
To be sure, absolutely.
They put in gold.
Yeah, and they put in gold over with embossed Babek writing, to be sure. Of course, and one can't disregard that.
Yeah.
But once you take into account, not necessarily giving it primacy, but if you take into account type of mark figurative,
Yeah.
and construe it all together, then that may lead you to the conclusion that what is sought to be registered is what we see in the picture and described in those words.
Yes, but not done properly, done in a way where the text
So
generalises.
you say the even so, that might have been the intention. I mean, of course, we don't know, and it's an objective question anyway. You say the words introduce ambiguity.
Absolutely, and my learned friend, on instructions for Hacon Skeleton and in response to the questions, took the express position that this was intended to cover multiple hues and it was intended to generalise. That can't be ignored. And there's a further reason, which is this, and it arose out of a question from Justice Newey, which is, if you have, there seems to be an agreement that there are multiple golds in this mark and multiple blacks if you're going to be generous as to what you consider black to be. If that's the case, you can't adopt the word gold safely or the word black safely, because you're bound to consider using a Pantone shade at that point, because it will always cover more. So you either take the real world view, which is, again, my learned friend defends the judge and says, well, he was taking a real world view. Well, if he's taking a real world view, this is just a gold object with shading and so on, then why does he say there are multiple colours and that we needed to have a long list of Pantone shades? You can't have it both ways. It's got to be one or the other. And we say the obvious thing. Sorry. I think I probably finished the point.
Just going back to that, so back in 2009, the rules said you had to indicate in words the colours making up the mark, and a reference to recognised colour code may be added. Now you've explained that an answer would be to say, well, the colours are as shown in the picture.
The colours gold and black as shown in the picture.
Okay, I follow that. was there any other solution that didn't involve adding a Pantone colour? I mean, how do you describe these colours in words?
First of all, the 3.5 says where registration in colour is applied for, the application shall contain an indication to that effect.
Well, it doesn't actually. If you go, sorry, I'm looking at the version quoted in paragraph 22 of the judgment, which I think is the one that was operative at the time. So Lord Justice Kitchen is setting it out, and I think at the time it was 3.5 as shown there. So it said the colours making up the mark shall also be indicated in words.
Yes,
and the reference may be
we're
out.
not sure that's right, actually.
So just to help you on that, my Lord Justice Newey looked at that over lunch,
All right.
and which is why he's asking the question. And the relevant amendment came in the 2005 amendment.
Right. Okay. Yeah, so and that's why it ended up in Glaxo, but it wasn't around when this mark was applied for. Right. Okay. So it doesn't have the words in words. So indicated could be is more general, a general way. As we see it, there are a number of options. You could either have, depending on what the rules were. I mean, if you're dealing with that rule, obviously you're now dealing with a situation where there is no requirement at all. You have no description, no need to indicate. But if you've got a situation where you've got to indicate the colours, then it is possible to say gold, black, as shown in the registration.
Okay,
So
no, I see the point about showing the
Or you can
registration.
say-
Can I just take it a stage further? Suppose we haven't got a complicated symbol such as we have here. We simply have something that is one colour.
Yes, exactly.
It is a shade
Life
of gold.
would be so simple. Yeah.
Quite. We have one colour which is simply a shade of gold, and now you want to register in 2009. So you've got to put in, you've got to indicate in words the colour. Well, what are you going to do? It's gold. You can't indicate any particular shade of gold except by going to a colour code.
Yes.
But that seems to be optional. So what word do you use to indicate the gold?
I'm not following, but I'm sure
No,
the word gold.
Yes,
Then
I mean,
you refer it back to the representation.
Suppose we simply have a picture which is entirely one colour, and the man in the street would say that colour is gold, or purple, or whatever. And you're told that you have to indicate in words the colour. Well, what do you put down?
Well, at this point, I'm bound to point out that there was, in fact, a case on this.
Oh, was there?
Which is the orange case. I mean, this is a very old case, so I'm not sure it's very authoritative. But orange applied to register an orange square, and it was not a colour per se mark. It was a figurative mark, but it consisted of an orange square because that's actually how they used it at the time. They put orange squares all over their packaging and in their advertising. And they tried to simply call it orange. And the answer was no, you had to give the Pantone number. But that was prior to 2005, so, and prior to most of the relevant case law, so query whether there's any authoritative value in that. I think it was only a Board of Appeal decision anyway. But it's discussed in the McBride decision. That's why it's in my mind.
Yeah, I see. And so the question is really, how can you designate, apart from using the name or the Pantone shade? And I think the answer is I can't think of a way of doing that. Yeah, and you can say gold as shown. So, but that's fine. I mean, there's nothing. putting that burden on the applicant, particularly where it has used multiple golds or multiple shades of gold, depending on what your view of the matter is, and multiple blacks, is a fairly light burden. The other point made by my learned friend in her submissions was that when it comes to figurative marks, a sort of pragmatic approach is to just, for most of them, to consider that the representation is the real mark and the rest is sort of unnecessary verbiage. That is not correct. I mean, these cases, if they tell you anything, it is that these you can't simply airbrush out that visual the textual description. It can cause problems, it can generalize, it can create uncertainty. And it was interesting and telling that the focus in her submissions was on inconsistency. And although we do have some inconsistency in our description here, in the use of the black, the law is not just inconsistency, but whether it gives rise to doubt. At the very least, Arnold, when it comes to your interpretation, this gives rise to doubt. The Red Bull case. My learned friend said, well, consistency and harmony will lead to a good and valid trademark. Well, we say there's a bit of inconsistency, and there's certainly quite a lot of doubt. I don't think I was going to.
Mr. Carter.
I had some very brief points of reply on grounds 3 and 5. In relation to ground 3, Honourable Justice Arnold asked what was meant by the word fixed. And I think I should, it's a word included in our grounds of appeal that we are ultimately responsible for it. All we really meant by it was a fixed category would be one that was essentially given precedence over the other elements of the graphical representation as a whole, and then used therefore to reconcile ambiguities or inconsistencies between those other elements. Is the way in which.
So I think it follows from that I was correctly characterising your argument. You say the way the judge went wrong was that he gave the categorisation precedence and he was wrong to do so.
Yes.
Yeah.
Because he should have spotted that other aspects pointed in other directions and that led to inconsistency and or ambiguity. And in further brief reply, my learned friend pointed out that the judge didn't say at paragraph 73 that the figurative categorisation trumped anything else. We agree with in terms there. I pointed you to paragraph 73 because we say that's the first hint of what he ended up doing at paragraphs 83 to 85, which is allowed to trump. And then very briefly on ground 5 as well, just my learned friend said that you could strike through the Tesco and Sainsbury bits. In reply to that, we say, as I tried to make clear when addressing you in chief, we don't really rely on it as an independent ground. Our overarching point is, yes, you could strike through those passages, but the judgment would still show an application of the incorrect text. This ground, ground 5, we rely on as showing an error which explains, at least in part, how the judge ultimately came to apply that test. And in reply to my learned friend's submission that in relation to the effect on other marks on the register point, my learned friend suggested that it wasn't took into account other marks on the register and the effect on other marks on the register. That wasn't the basis of his reasoning. With respect, if it is taken into account, then it forms at least a basis of his reasoning. And in fact, when you consider the way the judgment is phrased, the reference to making the finding invalidity in this case, making the trademark system unworkable, is made at paragraph 103, which is essentially the key. It's the penultimate paragraph of the entire judgment, just above the heading conclusion. And the conclusion just says that it's validly registered. So that where it's positioned, that to my mind suggests that it wasn't just a basis; it was a significant basis for the judge.
Thank you very much. Don't accept any more questions. You will be surprised to know that we're not going to give judgment here and now. So you will be supplied with the judgments in draft in the usual way for you to correct our typing in English, but not, of course, so as to re-argue the case. We'd be grateful if at that stage you would seek to agree in order dealing with consequential matters. If there are points on which you can't agree, can we please have brief written submissions, and we would expect to settle the points in the order that we make. Finally, I know you'll all be very familiar with this, but can I remind you of the importance attached to the embargo? I think we've already had, thank you, a list of those who you have in mind as receiving the draft judgment. If you think of anyone else who ought to receive it, you obviously need to come back to us rather than sending it out without our agreement. But thank you all for your very helpful submissions.
Authorising